Welcome to our YouTube video series on employment and labor law. My name is Christopher Neufeld of Neufeld Legal, and in this particular video, we will be discussing the limits of collective bargaining agreements. And why is it important to understand what the limits of collective bargaining agreements are for unionized employees? It's important because all too often those same unionized employees believe that what the collective bargaining agreement states is in fact compliant with the governing jurisdiction's employment standards legislation and other statutes and regulations. When all too often we have seen, especially in smaller jurisdictions, there is a lack of compliance as between the collective bargaining agreement and the employment standards legislation. And this is particularly damaging to those unionized employees because they fail to observe this discrepancy and are financially impacted by this. Because as we'll see as we look through employment standards legislation, collective bargaining agreements are required to comply with the statute and adhere to those minimums. Outside of those aspects, where the employment standards legislation provides for carve-outs specific to those collective agreements and thereby allows something other than the statutory minimums that are contained in the employment standards legislation. And for purposes of our analysis, what we're going to undertake is to look at Alberta's Employment Standards Code as a framework upon which we can show where the limits are to collective bargaining agreements. And of particular note is what we identify after we've done the statutory analysis, which will be coming near the end of this video. So what we start off with in looking at the Alberta Employment Standards Code are the definitions that are critical to this topic. We have two definitions. One being that of the agreement, which is found in section 1, sub 8.1, which says that an agreement includes a collective agreement, otherwise known as a collective bargaining agreement. And section 1, sub D, which says that a collective agreement means an agreement in writing between an employer or an employer's organization and a bargaining agent containing terms or conditions of employment and may include one or more documents containing one or more agreements. From there, we move on to some very particular language which is going to impact our analysis of collective bargaining agreements. And these pertain to the whole analysis and application of employment standards legislation in the province of Alberta and how agreements, including collective agreements, operate in conjunction therewith. First, we look at section 3 sub 1, where it says, nothing in this act affects A, any civil remedy of an employee or an employer, B, an agreement, a right of common law, or a custom that 1, provides to an employee earnings, leaves of the types described in Division 7 to 7.6, or other benefits that are at least equal to those under this act, or 2, imposes on an employer an obligation or duty greater than that under this act. Then we look at section 3 sub 2. If under an agreement an employee is to receive greater earnings or leave of types described in Division 7 to 7.6 than those for which this act provides, the employer must give those greater benefits. So what we see here is that you can go above the statutory minimums set out in the Employment Standards Code. But if you agree to provide those, you must adhere to those. So you can have something more than what is provided in the code. Next, we go to Section 4, extremely important. An agreement that this act or a provision of it does not apply, or that the remedies provided by it are not to be available for an employee, is against public policy and void. So now remembering that agreement includes a collective agreement, also known as collective bargaining agreement. The collective bargaining agreement cannot provide something that is less than what is set forth in the Employment Standards Code. And this is of particular importance for purposes of our analysis of both the collective agreement and the statutory minimums. Now, moving on, we look at the provisions that discuss how the collective agreement could change or alter provisions in the Employment Standards Code. And what we're going to pay particular attention to is where those provisions arise and what they pertain to. So Section 12, Sub 2. An employer may deduct from earnings of an employee a sum of money that is B, authorized to be deducted by a collective agreement that is binding on the employee. But then we need to look at 12, Sub 3, which says, despite an authorization in a collective agreement or a written authorization by an employee, an employer must not deduct from earnings a sum for A, faulty work as defined in the regulations of the employee or damage caused by the employee, B, cash storage shortages or loss of property if an individual other than the employee had access to the cash or property, C, cash shortages resulting from a failure to collect all or any part of the purchase price from a purchaser, or D, any other circumstance specified by the regulations. We also look at 16 Sub 3. This section, being the section on hours of work confined, does not apply if different hours of work confinement provisions are agreed to under a collective agreement. 17 Sub 3. This section, notice of work time, does not apply if different notice or hours of rest provisions are agreed to under a collective agreement. And 19 Sub 3. This section, days of rest, does not apply if different days of rest provisions are agreed to under a collective agreement. So in these past three sections, what we see specific carve-outs that are provided by the Employment Standards Code. Now we look at Section 23.1, which says, an employee or the majority of a group of employees may enter into an overtime agreement as part of a collective agreement, or if there is no collective agreement, in a written agreement between the employee or group of employees and the employer that provides that wholly or partly instead of overtime pay, the employer will provide and the employee or group of employees will take time off with pay instead of overtime pay. Followed by Section 23, Sub 2, Sub C. Instead of overtime pay, time off with pay will be provided, taken and paid to the employee within 6 months of the end of the pay period in which it was earned, unless the agreement is part of a collective agreement and the collective agreement provides for a longer period within which the time off with pay is to be provided and taken. Followed by 23.1 Sub 1.3. Subject to the regulations, an employer or an employer's organization and a bargaining agent may agree to an averaging arrangement as part of a collective agreement. So here we see in this section that we have the ability to undertake overtime agreements and averaging agreements as part of a collective agreement. And this is made possible by the specific provisions in the code. Next, we look at Section 63 Sub 1. The employment of an employee who is laid off for one or more periods exceeding in total 90 days within a 100-day period terminates, and termination pay is payable unless B, there is a collective agreement binding the employer and employee containing recall rights for employees following layoff. And thereafter, Section 63.4. Subsections 1 and 2 do not apply if different provisions for termination after temporary layoff are agreed to under a collective agreement. And finally, 64 sub 4. Subsection 3 does not apply to an employee bound by a collective agreement containing recall rights for employees following a layoff. Now, here again, what we are seeing is that with respect to layoffs, there is a specific carve-out that allows something greater to occur under a collective agreement that would allow for a recall arrangement. But this, once again, is a specific carve-out, specifically delineated within the Alberta Employment Standards Code. And this is a critical aspect that we have to consider, is that there is many different aspects that are not addressed within the Employment Standards Code in relation to collective agreements. And as such, where is the basis, if there is one, which we contend there is none, to deviate from the statutory minimums set forth in the Employment Standards Code? And those areas pertain to reporting, overtime pay calculations, vacation time and vacation pay, general holidays and general holiday pay, leave, termination and termination pay. Those areas are never addressed as it relates to collective agreements. And as such, the contention be, there is not the basis with which a collective agreement can go back and provide anything less than the statutory minimums. Because as we look back at the beginning of the code in sections 3 and section 4, you can offer something greater, but you cannot offer something less than what is requirement unless there is a specific carve-out for that purpose. And this is extremely important, whether it applies to the Alberta Employment Standards Code or the employment standards legislation of another jurisdiction. That is extremely important to understand the limitations of the collective agreement. And the limitations, in large part, are found by what is not addressed in the governing employment standards legislation. And if you understand that, and you understand where those aspects are, you can better understand the sufficiency of one's collective bargaining agreement and whether or not, as a unionized employee, apparently protected by a collective bargaining agreement, you are in fact being provided with the statutory minimums or not. Because what we see all too often is, for whatever reason, the collective bargaining agreement is not consistent with the jurisdiction's employment standards legislation and is providing amounts of pay and reporting and other arrangements that are below the statutory minimums, which is in contravention of the jurisdiction's employment standards legislation, and as such, something that must be of concern and addressed by those unionized employees. Thank you.